Tantor Audio, a division of Recorded Books, presents Safe Haven, the United Kingdom's investigations into Nazi collaborators and the failure of justice, by Jon Silverman and Robert Sherwood, narrated by Jon Silverman. Publisher's note: in this audio edition you'll hear references to figures present in the print and e-book formats of the book. Preface. It falls to the historian to excavate the lost and forgotten parts of the past, as well as the truths we don't want to remember. In the 1980s, when the UK woke up, or was woken up, to the realization that it had been playing host for decades to men who had committed crimes in the service of Nazi Germany, there was a feeding frenzy of concern in Parliament and the public prints. This led eventually, as David Cesarani has chronicled, to the passage of the War Crimes Act in 1991. Necessarily, the criminal and legal investigations which followed went on away from the public gaze. Yet, when the process came to an end in 2000, after one trial and conviction, the giddy intensity of the initial interest dissipated with the speed of air escaping a balloon, leaving behind many unexplored questions, such as why was there only one conviction when several hundred names came under scrutiny? Who were the other suspects? Why did the Crown Prosecution Service rule that perpetrators responsible for hundreds, if not thousands, of deaths should not face charges? Why were the issues at trial narrowed by the prosecution to the extent that the crimes were effectively decoupled from the Holocaust? And why do we know so little, in fact almost nothing, about the thinking behind the decisions which were made, particularly at the level of the Crown Prosecution Service and Attorney General's Office? It is the job of historiography to try to make sense of events through empirical discovery and conceptual analysis, and to evaluate the causation of behaviours which have momentous consequences. It may be thought that an obvious answer to one of the questions posed previously, namely, why was there only one conviction in the 1990s, is that the evidential trail, after a lapse of half a century, had inevitably run cold. That's certainly not the whole story, as we explain. But even if it was, there are unexamined issues, characterized by incompetence and apathy, arising from the military inquiries which began within weeks of the ending of the war, when the accuracy of identification and the memories of witnesses could hardly have been fresher. Although the focal point of this book is the investigations carried out by the UK, whether by the Army in the British zone of post-war Germany, or the Metropolitan Police in the 1990s, the experience of other jurisdictions, both behind the Iron Curtain and in the United States, and in Commonwealth countries such as Australia and Canada, throw light on some of the key issues, such as the tension between survivor memory and the requirements of forensic justice. Moreover, this is a story with contemporary relevance. Germany is still prosecuting elderly Nazis, and violently different narratives of resistance and collaboration continue to be a fault line in many parts of Eastern Europe. Anti-Semitism is a growing reality in many parts of Europe. And remarkably, truths and myths about Britain and Europe, rooted in the Second World War, can still be, well into the 21st century, a touchstone for political dissension. Introduction. Whither Justice? Beyond Nuremberg. On the first day of the Jewish Passover in April 1999, an English jury returned a verdict of guilty of murder on a 78-year-old man born in what is now Belarus. The crimes of which he stood convicted took place 57 years earlier in a portion of Eastern Europe aptly described by Timothy Snyder as Bloodlands. The defendant was a hitherto anonymous police auxiliary, far removed in status from Hitler's so-called paladins and Nazi functionaries called to account at Nuremberg for war crimes. Yet the small fry who murdered Jews in countless towns, villages and hamlets for at least 3 years left as indelible an imprint on the Shoah as those who operated the gas chambers at Auschwitz-Birkenau. The long tail of the Second World War is still impacting on Eastern Europe, with the chimera of dismantling Nazism one of the stated pretexts for Russia's invasion of Ukraine in 2022. Just as the crimes of Hitler's perpetrators have periodically played out in courtrooms, from Nuremberg to Frankfurt, Warsaw to Jerusalem and beyond, so Putin's may yet face the verdict of war crimes trials, both domestic and international. Whether that happens or not, the pursuit of justice will provide lawyers, investigators and academic researchers with meat to chew on for years to come. Justice is a word which slips seamlessly into everyday discourse, ranging from the banality of a disputed parking fine to a wrongful conviction for murder. Despite, or perhaps because of its common usage, there is an overwhelming sense of inadequacy when applied to the Holocaust, the outcome of an enterprise not merely massive in scale, but also bureaucratically organized and state-directed. The roots of the term justice can be traced back through Latin to Greek, while both the Old and New Testaments provide layers of commentary and interpretation. The biblical incantation, an eye for an eye, represents the infliction of reciprocal mimetic violence, which was enacted in wartime Germany as lynch justice. Churchill's version of victor's justice was the proposal that 50 to 100 of the leading Nazis should be shot to death without reference to higher authority. The United States Assistant Secretary of War, John McCloy, countered that summary execution without trial is contrary to the fundamental conception of justice. And since the American view prevailed, the creation of a multinational tribunal, constituted as a unique court of law at Nuremberg, has defined war crimes justice in the decades since. The corpus of historiography on the Holocaust grows year on year, and within that there is a smaller but far from negligible focus on war crimes trials from which much can be learned. David Ben-Gurion called the trial of Eichmann in Jerusalem the Nuremberg of the Jewish people. But in purely juridical terms, that's a misleading analogy. The landmark prosecutions of the surviving Nazi leadership at the International Military Tribunal, the IMT, at Nuremberg, sought evidence primarily from captured German documentation. The Eichmann trial foregrounded live witness testimony. Studies of other trials in Poland, Germany and elsewhere have teased out the degree to which there is acknowledgement that the Jewish Holocaust was central to the case being tried. Examination of Soviet show trials of the 1960s, some in person, some in absentia, illustrate the role of ideological triumphalism in the face of perceived Western atrophy. And at least one trial, that of Klaus Barbie in France in 1987, was as much about the host country and its post-war politics as it was about the defendant. Trials are necessarily a site of convergence between law and history. As Erich Haberer has written of the West German Nazi trials, both disciplines have their own rules and discourses, which must be observed. David Fraser rightly reminds us that the agenda of historians and political scientists is not the agenda of lawyers, police and judges. Law and history have different aims, different methodologies, and different fates in mind for their subjects. This work might be characterized as historico-legal in intent, rooted in the British tradition of empiricism, for example, channeling the spirit of authors such as Ian Kershaw and Richard Evans, and pursues a path less well trodden than preceding studies. The courtroom trial is a piece of public theatre, literally so in the case of the trial of Adolf Eichmann, which was reconceived as a play, The Man in the Glass Booth, by the actor-writer Robert Shaw. This research concerns itself not with the spectacle of trials, nor with the performative strategies of advocates, but with the pathway intended to lead to a trial. The route to Nuremberg, via the London Conference, which prepared the charter of the International Military Tribunal, has been exhaustively plotted by historians. But not so the two criminal prosecutions in the United Kingdom, which, as the opening line of this introduction suggests, is the locus for our point of departure. Of course, no equivalent is implied in terms of legal significance between Nuremberg and the UK prosecutions, but it is perhaps even more remarkable that Nazi collaborators were forced to submit to forensic scrutiny half a century later in a country which had not been occupied, if one excludes the Channel Islands. But this came at a cost, and it is undeniable that the due process flagrantly denied by the Nazis to their victims was the very reason that the UK's belated instrumentalising of justice fell so short. The two UK prosecutions were the fruits of several years of investigations by police officers and historians, necessarily carried out below the radar of public scrutiny. How did the detectives from the Metropolitan Police War Crimes Unit, the WCU, go about this task, and what incriminatory or exculpatory details were they searching for? What constraints on prosecutions were placed by lawyers from the Crown Prosecution Service, the CPS, and Treasury Counsel? We're able to fill in many of the knowledge gaps by interrogating some of those intimately involved, and by examining a hitherto untapped resource, tapes and transcripts of police interviews with some of the key suspects. These include a platoon captain of a notorious Latvian killing unit, and several of the Belarusian police auxiliaries considered for prosecution, as well as video and audio recorded interviews with Simon Serafinovich, the first person in the UK to be charged, whose prosecution was eventually abandoned on the grounds of his dementia. Here we see him in a suburban police station, shortly after he was identified as a prime suspect, a man evidently in possession of his faculties, seemingly comfortable with telling his story in a mixture of broken English and Russian, and with a remarkable grasp of recall given his 83 years. This is history unmediated by lawyers or historians, as vivid as the first-hand memories of survivors which have underpinned foundational works such as Martin Gilbert's The Holocaust, 1986. The UK faces its past. One interpretation of justice, transactional though it might seem, is the investigatory search for evidence, and the building of a jurisprudential case with the purpose of placing alleged perpetrators before a court. In the 1940s, in the retributive aftermath of the war, that court was a tribunal of military judges, sitting in the British-occupied zone of Germany. In the 1990s, responsibility for a verdict rested with a civilian jury at the Old Bailey in London. The unexpected resumption of inquiries in the 1990s, strongly opposed by many, offers unique opportunities for research. Unique in a juridical sense, because England and Wales was the only jurisdiction in the Commonwealth to achieve a conviction, when in a bout of belated reassessment, many hundreds of suspected elderly Nazi collaborators, mainly from Eastern Europe, became the subject of criminal inquiries in England, Canada, Australia, New Zealand and Scotland. Also unique in a cultural sense. There are many paradigms of identity which define Britain's self-image in the 21st century, and one of the most enduring is the narrative of an island nation standing alone against European tyranny during the Second World War. It's imagined as an uncomplicated parable of goodness set against the evil of Nazism. By contrast, the failure to prosecute and convict more former Nazis and their collaborators in the decades after 1945 has neither tarnished this image nor troubled the national conscience. Perhaps the mistaken belief that the survivors merely wanted to be left alone to get on with their lives without being reminded and reminding others of the past was too firmly rooted. Unlike France and the nations of Central and Eastern Europe occupied by the Nazis, the Holocaust is not embedded in the landscape of the English countryside. In 1979, Yehuda Bauer could justifiably tell a conference that nothing at all has been done in Britain to engage with the Holocaust. In the last 4 decades, tentative engagement has flowered into Holocaust consciousness, an umbrella term for a steady accretion of cultural initiatives around memorialization, and a toolkit of educational programs demonstrating that the Holocaust has both an intrinsic and an instrumentalist significance. And it's worth asking whether this process interacted in any way with legal efforts to prosecute some of the surviving perpetrators, and if so, how. In 1995, teaching the Holocaust gained a new prominence in the revised national curriculum, a development which underpinned Andy Pierce's contention that Britain was thus more aware and receptive to the Holocaust than any time previously. The year 1995 marked the 50th anniversary of the final defeat of Nazi Germany and of the liberation of Bergen-Belsen, the signifier of the Holocaust in Britain's immediate post-war narrative, even though it was not a death camp. And in that same year, preparations for Britain's first war crimes trial gathered pace, with the announcement of the first prosecution under the War Crimes Act. Yet, as we demonstrate, there was a striking dissonance between the rising tide of Holocaust awareness and the thinking of those in pursuit of a juridical reckoning, whether police or lawyers. How then should we consider the one criminal conviction of a Nazi collaborator achieved in the UK? If it served the cause of justice to disinter a 57-year-old act of violence committed in the context of a world war and pronounce judgment, what chain of decisions led to that outcome? To frame one of the questions we ask in the terms expressed by Lawrence Douglas, did the law create a coherent, judicially manageable response to unprecedented crimes? Or did the law and lawyers contrive to turn the criticism that the war crimes legislation was too little, too late, into a self-fulfilling prophecy? We can best respond to that by parsing Douglas's reflection. Coherent would be an overgenerous description of the approach taken by the English legal authorities, as we explain. As for judicially manageable, the answer must be a heavily qualified yes, but achieved by effectively untethering the charges from the enormity of the final solution. As Weinert puts it, placing the crimes in a conventional dialogue of murder. This didn't mean dismissing the geopolitical context in which the offences had been committed, but rejecting the view taken by the United States, for example, through a Supreme Court ruling, that complicity could be assumed if a suspect had been a member of a notorious Einsatzgruppen squad. Hannah Arendt famously critiqued the Eichmann prosecution on the grounds that a national court should not arrogate to itself, for political reasons, the right to try genocide and crimes against humanity. The Anglo-Saxon nations, which faced the issue of prosecuting war crimes in the 1980s and 1990s, grappled with this question in another way. In the case of Australia, the legislation which amended the 1945 War Crimes Act incorporated the crimes against humanity or genocide element of international law into the statute. Subsection 3 specifies in terms that the act be done, 1, in the course of political, racial or religious persecution, or 2, with intent to destroy in whole or in part a national, ethnic, racial or religious group. The wording of the UK War Crimes Act 1991 is spare in the extreme, but it finds space to include the discourse of the Geneva Conventions, which prohibit acts that contravene the laws and customs of war. But the linguistic formula deriving from internationally recognized norms does not change the fact that common law precedent was always paramount, meaning the need to convince a jury of a suspect's guilt in specific circumstances, at specific times, underpinned by credible eyewitness evidence. David Fraser, who examined the 3 Australian prosecutions, has described this Anglo-Saxon approach as constructing a limited tale of mens rea, actus reus, identity and so forth, in which the shower is displaced somewhere near or beyond the boundary of legal practice. For the UK prosecutors, developments in international law deriving from the Nuremberg tribunals were of contextual interest only. Rajka Vlahovic, who headed the Crown Prosecution Service casework team, which prepared the trial of Andrei Savoniuk, said, "At first the CPS was looking at prosecutions from a war crimes perspective. But then we took the decision that these were straight murder cases and proceeded accordingly." When asked whether any members of the Metropolitan Police War Crimes Unit had any knowledge of the Holocaust, Detective Chief Inspector Dermot McDermott replied, "No, only from school. It was a murder investigation. Never lost sight of that." From an instrumentalist viewpoint, this made sense. The investigators and prosecutors knew what they needed to do to mount a winnable courtroom contest in front of a jury. But it could be plausibly argued that the gain of one conviction was achieved at the cost of promoting a wider appreciation of how the actions of a cohort of Belarusian policemen fitted into the wider tableau of the Nazi Holocaust. In this there are strong parallels with the planning and conduct of the post-war Belsen trial, in which, for the British public, the Jewish genocide was at most a spectral presence, only discernible through newsreel footage. There's little dispute that the Eichmann prosecution was the first to consciously put the Holocaust on trial, with the defendant cast as a vector for the entire criminal enterprise. Douglas argues that it served to create the Holocaust. The Eichmann case opened the door to a second wave of juridical reckonings with the Nazi past in the Frankfurt Auschwitz trials. Israel's motivation in trying Eichmann was clear: to show the world that the final solution had failed, and that a self-confident Jewish nation had emerged from the ashes of the European genocide. Whereas historians offer different interpretations of the strategic approach taken by the West German courts in the 1960s and 1970s to the major concentration camp trials. For Mary Fulbrook, these prosecutions generally chose to focus on the personal motivation and excess deeds of defendants, who were seen as being accused of committing individual crimes rather than being part of a wider crime complex. Erich Haberer, though, argues that West German prosecutors, following the lead of the first director of the Ludwigsburg Zentralstelle, Erwin Schüler, marshalled evidence according to a cluster approach, to demonstrate that a unit was operating to a systemic murder complex enforced by the Nazi state. What is indisputable is that since the reunification of Germany, and more particularly since a landmark legal ruling of 2011 following the Demjanjuk case, the pendulum has swung decisively towards a focus on the wider crime complex of the final solution, represented by the network of concentration and death camps and those who served in them, however minor their role. As Mary Fulbrook points out, the impact on the fabric of the nation has been profound. Perhaps most striking of all is the way the Holocaust has become central to the identity and culture of the Federal Republic of Germany, incorporated into its material and moral fibre. Even more remarkably, deep into the second decade of the 21st century, Germany's War Crimes Agency at Ludwigsburg gained approval to extend its jurisdictional reach to include a suspect who was not German, who'd been investigated but not prosecuted in another country and was living outside German borders, in this case the United Kingdom. Recounted in Chapter 7, the story of German interest in Stanislav Chronowski, a former auxiliary policeman, so-called Schutzmannschaft, whose crimes were committed in Belarus, can be read either as a rebuke to the UK authorities, which declined to prosecute on the grounds of insufficient direct eyewitness evidence, or as an idiosyncratic interpretation of the principle of universal jurisdiction. As Andrzej Umański, a legal researcher at the University of Cologne, commented in 2018, "I would say we are pushing the law to its maximum and showing that crimes will be punished even 70 years afterwards because they were so grave." The process of legal accountability for the Nazi project has now outlived the Second World War by nearly 8 decades, though acknowledgement in Germany that the country bore a unique responsibility for the Holocaust didn't begin to take shape until the trials of the 1960s and was not fully formed until the 1980s. The German concept of overcoming the past is inevitably a work in progress. The continuing need to seek judicial expiation for the sins of the grandparents and great-grandparents, in this context the sin of leaving unpunished many thousands of perpetrators in earlier decades, perhaps requires less deconstruction than does the United Kingdom's investigations of the 1990s. Which makes it all the more surprising that even those few scholars who've studied the 2 English prosecutions, Hirsch, Bloxham, Laputzka, have not strayed far from the courtroom, sidestepping the more intriguing contextual questions. For example, how did the English legal authorities determine who merited prosecution, and which victims were deemed more worthy of juridical acknowledgement? In seeking to answer these questions, we lay bare in detail just how inconsistently the UK's normative procedures were applied. Command responsibility and Jewish victims. On the 29th of March 1999, as the jury was being sent out to consider its verdict in the case of Anthony Andrei Savoniuk, the press corps at the Old Bailey was handed a 4-page document prepared by the Metropolitan Police War Crimes Unit. It was intended to help those not immersed in the detail of 8 years of war crimes inquiries appreciate the remit and magnitude of the task faced by the police as they conducted a global search for evidence. In fact, though, this utilitarian briefing document contained information which casts a fresh light on the methodology followed by the UK investigators, suggesting that the search for prosecutable war criminals was circumscribed from the very outset. It sets out the 4 criteria to be met before a suspect was considered a serious candidate for prosecution. The first 3, relating to eyewitness evidence, identification, and provable allegations of mass murder of non-combatants, are uncontroversial. The 4th, though, is in a different category. Proof that the defendant was in a position of command. Responsibility is also an important factor in deciding on the defendant's culpability. The clear implication of this criterion is that a jury would believe that a person in command bore a greater degree of responsibility than those who were merely following orders, though it stands in contrast to the charter adopted by the International Military Tribunal at Nuremberg in 1946. Article 8 of the charter stated, The fact that the defendant acted pursuant to an order of his government or of a superior shall not free him from responsibility, but may be considered in mitigation of punishment if the tribunal determines that justice so requires. This command criterion...
Sample complete. Ready to continue?